So back on the record, state's attorney's present, defendant, defense counsel are present. There's been something brought to my attention by Deputy Millhouse this morning, and what's his juror number, Mr. Cooper, number 15, works at LaSalle, and after court yesterday went to work, and in his uniform ended up on the elevator with Miss Samuel at LaSalle. He said nothing was said, but he obviously let Deputy Millhouse know. I also think that the other jurors heard that conversation and know that happened. Now, Miss Samuel's testimony, she said that she's been in custody. So I think, I'm not sure really what to think. So typically that would be a huge issue, but she did testify yesterday that she had been in custody.
She testified that she's been in jail for the last, I believe, 15 to 16 months, that she's been clean that whole time. And so the jury knows that part. So if the issue is, well, now they're aware that she's in custody, I think that any idea of that being prejudicial is kind of a moot point because they already knew that.
Mr. Vasquez?
Judge, I think because of the appearance of impropriety that I have to ask for a mistrial. I think on behalf of my client, I have to ask for a mistrial.
Let me do this before I rule on anything or make any decision. I'm gonna, let's just go off the record. I'm gonna do just a quick little research.
Run upstairs and ask them.
If everybody kind of take a look at any kind of case law that you can find with regard to that. And else that we need to take care of with regard to the charge or anything before we bring the jury back in, Mr. Nichols?
No, Your Honor.
Mr. Vasquez?
No, Your Honor.
And no other requested additions or objections or corrections to that charge?
Nothing other than what we've already covered.
All right. Same, Mr. Vasquez?
Same, no, just what we covered before, what I asked for.
Thank you. You can bring the jury in. Thank you. Good morning. Thank you guys for your patience this morning. We are back on the record. Jury seated. State's attorneys present. Defendant and defense counsel are present. At this time, ladies and gentlemen, I'm going to read the court's charge. I'm required to read it in full to you, and then you will have a copy to bring back with you into your deliberations. Cause number 23, DCCR 1793, the State of Texas versus Tracy Marie Samuel. Members of the jury. The defendant, Tracy Marie Samuel, is accused of murder. The defendant has pleaded not guilty, and you have heard all of the evidence. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable in this case. General principles. The indictment is not evidence of guilt. The indictment is a document required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, or indicted or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient for you to return a verdict of not guilty. You may find the defendant guilty only after careful and impartial consideration of all of the evidence, and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty simply means that the state does not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on the verdict. When you reach a verdict, the foreperson should notify the court. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to select your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with the other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4. You must not conduct any independent investigations, research, or experiments. 5. You must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use the form attached to these instructions. The foreperson should sign the line that corresponds to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Law specific to this case. The defendant stands charged by indictment of having committed the offense of murder. You will also be asked in further detail below to consider the lesser included offense of manslaughter. Relevant statutes. A person commits the offense of murder if the person intentionally or knowingly causes the death of an individual. A person commits the offense of manslaughter if the person recklessly causes the death of an individual. Definitions. A person acts intentionally or with intent with respect to the nature of her conduct or to a result of her conduct when it is her conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause the result. A person recklessly causes the death of an individual if 1. There is a substantial and unjustifiable risk that her conduct will cause the death. 2. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the person's standpoint. And 3. The person is aware of but consciously disregards that risk. Intoxication means a disturbance of mental or physical capacity resulting from the introduction of any substance in the body.
This is the moment everything changes. The judge has finished explaining the law, and now the jury gets the roadmap that will decide this entire case. Here's the key question. Was this shooting an intentional act that qualifies as murder, or was it reckless conduct that could reduce the charge to manslaughter? That distinction isn't just legal wording. It could completely change the defendant's future. Based on everything you've heard so far, which verdict do you think the evidence supports? Let me know in the comments before the jury reaches its decision.
Application of law to the facts. Although the state has charged the defendant with the offense of murder, you may find the defendant not guilty of that charged offense, but guilty of any lesser included offense. In this case, the offense of manslaughter is a lesser included offense of the charged and greater offense of murder. In order to find the defendant guilty of manslaughter, you must first find her not guilty of murder. To find the defendant guilty of murder, you must determine whether the state has proved, beyond a reasonable doubt, 2 elements. The elements are that 1, the defendant, Tracy Marie Samuel, in Jefferson County, Texas, on or about September 27, 2023, caused the death of Delbert Charles Lewis by shooting Delbert Charles Lewis with a handgun, and 2, the defendant did this either intentionally or knowingly. You must all agree on elements 1 and 2 listed above. If you all agree the state has proved beyond a reasonable doubt both of the elements listed above, you must find the defendant guilty of murder, and so indicate on the attached verdict form titled Verdict Guilty of Murder. If you all agree the state has failed to prove beyond a reasonable doubt one or both of elements 1 and 2 listed above, you must find the defendant not guilty of murder. You may then determine whether the state has proved beyond a reasonable doubt the lesser included offense of manslaughter. To find the defendant guilty of manslaughter, you must determine whether